We're cooling. Let's go.
Court does call the case People versus Dylan Chapman.
Your Honor, Alexis Plumey, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today is the date set for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for counts 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5
Correct.
and would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendant's not guilty plea as to count 6 and 7. Set this matter for pretrial.
January 29th at 10:30 for Judge Brushour.
That date might change. There's an in custody. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Fresh Hour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident.
All right. Just focus on what the attorney just said. He feels comfortable with me telling this story to the court. That is her ducking her head in the sand. Like, nope, I have nothing to do with this. This is his story. I'm just saying what he said. Okay, get ready.
Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there. So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Fresh Hour so that if there is more detail that needs to be provided, Judge Fresh Hour could consider that.
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. At this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court consider. Yes, Your Honor.
That his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
Clean sheet.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that in case the complainant needed to use his debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the report
How do I
whether.
know the complainant's not there if she had the car? From this defendant?
So the complainant's not at the scene of the accident.
Yeah.
Right, we don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant. The vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why his wallet, ID, all of that stuff is still there because he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that.
Yeah.
But none of the other part makes sense. Well, I'm not. Anything else?
No, Your Honor.
I think when I look at everything that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation. I'm revoking the defendant's bond. The defendant is remanded.
Yeah. So that was a good story, right? Yeah, I didn't buy that he was. I didn't know that the whole angle was the victim was actually there. I thought he was just driving. He was blaming it on the victim. I thought that's what he was doing. No, that's even it's so much worse. So much worse. Nice try though with that story. And the attorney kept trying to duck out of it. I know the story doesn't make sense, but this is what he told me. All right. That's about it. Thank you guys so much for watching. Hit that like button on your way out. I would appreciate it. Also, leave a comment. Hi. What's the other thing? Subscribe. Oh, yeah. I knew there was 4, and I only had 3 of the 4. Anyways, that's it. That's all I got. Until next time. Bye.
Calls case, people versus Carlos Hicks.